Well, hello and welcome to News Centre. I'm Ashmit Kumar. Now, top lawyers Harish Salve and Mukul Rohatgi have urged the Supreme Court to curtail the powers of the Enforcement Directorate. They said, and I quote here, "No one is safe in the country if the ED is not reined in." End of quote. Now, the two lawyers were arguing against the arrest of their client, Basant and Pankaj Bansal, the promoters of Gurugram-based realty group M3M Developers. The lawyers also argued that the ED arrested the directors when they had been cooperating. Further, according to the ED's data, under the Prevention of Money Laundering Act, only 24 cases have seen conviction till 31st of January. The number of accused convicted under the money laundering law stands at just 45. Concerns over the probing agency's arrest powers are not new. In April this year, 14 opposition parties had filed a petition in Supreme Court against the arrests made by the ED as well as the CBI of opposition leaders. However, the Supreme Court dismissed the petition. And joining us now to discuss all of this and a lot more, I'm now joined by Mr. Dushyant Dave, a senior advocate of the Apex Court. Mr. Dave, thank you so much for joining us. I'll just recount those words once again from Harish Salve. Drastic powers given to the ED. If not reined in, no one will be safe in the country. Your thoughts on that? Do you agree with that?
I fully agree with that. I think ED, originally trained its guns on politicians. Now it is training its guns on business community. And, it is really sad the way these powers are being exercised, thanks only, of course, to the Supreme Court, which, gave those powers to the Enforcement Directorate. So the powers are being used more often than not abused. And it's not good for citizens that they should be subjected to this kind of draconian powers and, this kind of a very, I would say, harsh treatment that they receive both at the hands of the ED officials and at the hands of the judiciary to a great extent, I must say.
Mr. Dave, let me get your thoughts. You spoke of the Apex Court. The Supreme Court was seized of the matter. There was a whole batch of applications that the Supreme Court was hearing. But in July of last year, the Supreme Court made a decision that everything is kosher with the PMLA. There is no need for intervention and that the ED's powers are justified. You think that that is a lost opportunity from your perspective for the Apex Court?
See, there is no doubt about the fact that the judgment of the Supreme Court in Vijay Chaudhary, which Justice Khanwilkar authored, that is one of the, I would say, darkest chapters in the history of the Supreme Court, because that judgment has virtually turned the law upside down on every principle. The basic principles of criminal jurisprudence, the fundamental principles are twofold. One, presumed innocent, and two, burden of proof. Now, every person who's charged with a criminal offense is presumed to be innocent till he's proved guilty. One. Two, the burden of proof is always on the prosecution or, the authority which is leveling the charge against it. I think, yes, Justice Khanwilkar has turned that upside down and said that, no, you are presumed to be guilty if, you have been proceeded against, one, and two, that you have to prove yourself that you are innocent. So, besides the fact that the Supreme Court, Justice Khanwilkar's judgment said that it is not necessary to give even a copy of the what is known as the ECIR, which is equivalent to a first information report to the person charged. It is good enough if he has indicated the grounds. The judge before whom he is produced will satisfy himself. Now, this takes away the complete right of citizen to defend himself or herself, which is unheard of. And then coupled with that, they say that summons by ED is not an arrest. ED is not a police authority. Therefore, the statements made before the ED are admissible in court. And any kind of a criminal case can be brought within the jurisdiction of the PMLA Act. All these Supreme Court said in this judgment, which is truly, to my mind, I think I would characterize it as one of the worst judgments in the history of Supreme Court since independence.
You pointed out plenty of lacuna with that judgment, but how telling is it that in less than 30 days of that judgment, the Apex Court decided to hit the pause button and said that, look, wait a second here, there's perhaps room for revisiting this judgment. And there are two aspects that, in fact, it was said in open court as a part of an observation that need to be revisited. Number one, whether or not the ECIR should be supplied to the accused, and number two, whether or not the burden of proof should be on the accused. How telling are these observations coming from the Apex Court less than a month after the judgment?
They are, and I have no doubt that these observations were correctly made. I would say that it's not just these two issues. I think there are many issues on which this PMLA Act. You must understand one thing. It is conceived as part of international conventions to which India is a party, and these conventions were essentially to fight international drug traffic, international corruption cases, and the monies which are taken by the corrupt politicians from across the world into tax havens, and to fight terrorism and financing of terrorism. It was never intended for ordinary criminal cases. So today the act has a schedule in which all kinds of offenses, including under Copyright Act, are brought within the purview of the PMLA Act. The simple cases, including under cheating under Section 420 of the IPC, for example, is brought under that. So as a result of that, I know of a case in which a shareholder filed a case against the managing director of a company saying that, oh, you had cheated 15 years ago. And in that particular case, the Reserve Bank had found that there was no cheating. There was impropriety. Impropriety was corrected. Reserve Bank was satisfied. 15 years later, some shareholder files a case, and within a week thereafter, the ED swoops down and attaches assets worth over 1,000 crores. Now, is this the kind of power that should be exercised by the... Today, ED is completely unchecked by the executive bosses. So, only check can be judiciary. And judiciary is unable to, keep that check. In every case, people are being, sent to jail, and people are not able to come out. Trials will take 5-10 years. So, and as you rightly said, the, rate of conviction is very low. But coupled with that, the number of cases that ED has registered has been, I think there is an increase of 10-fold times in last 5 years over a previous period. So I think there is definitely a gross abuse which is taking place here. It would be high time for government really, because ultimately government also must realize that business community needs to, flourish, needs to do business. And if there is anything which is, I am not for a moment justifying wrongdoing by the business community. If they have evaded taxes, they must be proceeded against. You have income tax law. But to bring every kind of a charge under PMLA, arrest people, and then, keep them in, because Justice Khanwilkar said that, no, you are not even entitled to bail, virtually. So, since the burden shifts on you, ED stands up before the court. Every judge in the country says, yes, now you have been charged, therefore we can't release you on bail. Now, this is really a catch-22 situation. We don't need this kind of a, scary atmosphere, because our entrepreneurs, our business community is extraordinarily, good in working and taking this country forward. We don't want to create an atmosphere where the business community feels pressured unnecessarily, avoidably, and, is unable to grow as it must grow. And without their growth, I think this country can't grow.
Right, Mr. Dave. You were mentioning of the cases that have been registered by the ED. Just to bring up those numbers, in 2014, 209 cases. In 2021, that's 3,985. That's a jump of nearly 2,000% over 7 years. So those were the numbers, Mr. Dave, that you were referring to. But again, to play the devil's advocate here, to recount some of the arguments that the centre has made, the centre's stance consistently has been that, look, these are very sophisticated offences that we're dealing at. It needs dedicated, specific legislation with special powers, and that minus these powers, the entire process, the entire purpose of the PMLA would be defeated. That's the government's position.
Well, I have no doubt government has a perspective. But as I said that, this law was essentially to fight drug money, terrorism money and corruption money. It was not to fight, income tax evasions or, some kind of a black money which, somebody in business may have. That's gross abuse, according to me. And look, there is a selective targeting here. You are not seeing anybody who is closely associated with the ruling party, whether, as MPs or MLAs or as ministers, or those who are, closely connected to the ruling party from the business community being even touched, even investigated. There are business, leaders today who have brought billions and billions of dollars into this country through Mauritius route. Everybody knows that. And we know how these monies are coming in. But yet no investigations are taking place against such people. So my fear is this, I am not for a moment justifying, anybody's wrongdoing. They must be proceeded. You have the ordinary law available to you. The income tax law has sufficient provisions. You have, GST Act under which you have sufficient provisions.
Sure.
But you cannot use this kind of a draconian law to, target people. That, according to me, is wholly unacceptable. We are a very civilized society. We are a democracy, which is a liberal democracy, a vibrant democracy, as Prime Minister time and again tells us. In such a democracy, abuse of this power or even use of this power, to my mind, is anathema to constitution and constitutional protection.
One criticism, Mr. Dave, of the Supreme Court's PMLA judgment has been that there was no intervention despite there being issues of liberty. For instance, the grounds of bail, the threshold for grant of bail is much higher here. The court has to form a prima facie view that the accused is innocent. Also a question of arrest, no notice to be given ahead of arrest. There is no mandate for recording or sharing of the ECIR, which raises the question whether or not the accused person will be able to defend himself or herself before a court of law. So these are questions of liberty which have been raised. How important is this now for the apex court to consider the entire debate around PMLA from the perspective of life and liberty?
I don't think there is a very great debate required. That judgment has to be recalled. That judgment cannot be allowed to stand even for a day. It is really a sad commentary on the part of the Supreme Court that 3 judges of the Supreme Court sat in that bench and delivered that judgment, although it is authored by Justice Khanwilkar. I feel that it would be high time for the current Chief Justice of India, Justice Chandrachud, to ensure that somehow this matter is taken up and it is reviewed and recalled as soon as possible before other people are being targeted. Because for citizens, even a day's liberty is crucial, is very important. You are taking away liberty of large number of people, from the politics to businesses to professions. It's not required. You don't need it. What have you achieved? Have you been able to stop black marketing? You haven't. Have you been able to stop black money? No, you haven't. That's why you are now demonetizing 2,000 rupee notes. So all these powers are only for the purpose of abuse and nothing else. Nobody is checking, nobody. There are nothing coming out about this. There is no supervision, there is no guidance. And I think judiciary, which is supposed to be a protector, has failed to protect. So I think judgment, as Chief Justice Chandrachud stated the other day, that judgment on statutory, bail, that kind of a stay he should grant so far as this judgment is concerned. He must immediately say it. If maybe government will not move naturally because government is happy with this kind of draconian powers, but somebody must mention to him and he must state. If he can state at the instance of the government something which is in favor of the government, he must stay at the instance of citizens to protect their liberties, even if it is a single individual's liberty for a single day. And here, hundreds and thousands of people are suffering today in the country. There are all kinds of raids taking place. There is a fear atmosphere which is developed in the country. And I can tell you one thing, that in the business community, people are really very seriously worried about. Very seriously, which is not a good thing, because business community is as important in our society as any other section of societies.
Right, Mr. Dave. Thank you so much for your time and perspective. Strong words, as always. A message for the chief, for the bench to consider this matter. And just for the perspective for our viewers, the review application is still pending before the top court, and there is room for some action there at the top court. Mr. Dave, thank you so much once again for sharing your time and perspective with us. But with that, it's time now to slip into a very short break. But coming up, the much-anticipated Digital Data Protection Bill has been cleared by the Cabinet and is likely to be tabled in the monsoon session of the Parliament. We assess the possible impact of the bill when we come back.